Bonjour à toutes et à tous. Hello, everyone. Welcome to the virtual edition of WeRobot 2020, the premier international conference on law and policy relating to robotics, hosted this year by the University of Ottawa Centre for Law, Technology and Society. Reinvented in the times of COVID-19, WeRobot 2020 is presented with the generous support of Microsoft, CIFAR, X, and Intel, as well as the University of Ottawa, the University of Washington Technology Policy Lab, and Miami Law. For those who are not familiar with the WeRobot format, please note that the authors do not present their own work. Instead, session discussants read authors' papers in advance on the conference and present the author's work to the audience while offering constructive thoughts for improvement and seeding the conversation that follows. Authors then have 5 minutes to respond to discussants' feedback. Then the session opens usually to the floor. For the virtual edition, we invite the audience to engage with the papers in the comments section below the video. For this session, we are delighted to welcome as discussant Woody Hartzog, a professor of law and computer science at Northeastern University, to present two papers on facial recognition and identity manipulation. The first one by Rui Ding from Stockholm University, titled Legitimate Uses of Facial Recognition Technology in Surveillance, Risks to Personal Integrity and Regulatory Challenges Facing the EU. The other from Susie Dunn from the University of Ottawa, titled Identity Manipulation, Responding to Advances in Artificial Intelligence and Robotics. Without further ado, I will hand it over to you, Woody. Thank you very much.
Thank you so much, Florian, and a huge thanks to you and the rest of the WeRobot Planning Committee for pulling this together. We were all, of course, heartbroken that we didn't get to come visit Ottawa and that we were not able, as planned, to pay tribute to our dear friend Ian Kerr. But I am optimistic for this online event and other events in the future. So thank you very much for your hard work, and it's greatly appreciated. So I'm thrilled today to be able to present two incredibly interesting papers. And I'll start by sort of summarizing just very briefly the papers, what they set out to do, and then give a few pieces of feedback and some thoughts on both of the papers. And then I'll turn it over to the authors for a response. And then we can have a conversation after that. I hope that works great. So the first paper by Rui Ding is about the legitimate uses of facial recognition technology in surveillance, risk to personal integrity, and regulatory challenges facing the EU. So Rui tackles a problem that I have also been worried about for some time now, and that's facial recognition surveillance. While some scholars and advocates like myself have argued that for an outright ban, that facial recognition technology should be outright banned, Rui argues that regulating facial recognition surveillance, not banning it outright, is the right approach for the EU. And if it's going to be regulated, then the EU is going to have to find grounds to legitimize that kind of behavior, which is the exact purpose of Rui's paper. The aim of the paper is to provide solutions to the challenges of facial recognition surveillance for personal integrity challenges. Rui asks, how should the EU ensure sound regulation of facial recognition surveillance to control its legitimate uses in minimizing risks to personal data? Rui then goes on to identify the risks to personal integrity caused by facial recognition technology, identifying three different risks. The first kind is identification risks. The second kind of risk is profiling risk. And the third kind of risk is security risk. Rui then examines the frameworks that can be applied to regulate facial recognition surveillance, which largely stem from the scale of the surveillance that is enabled by facial recognition and how easy it becomes. And then Rui identifies a series of gaps within the existing EU framework that can be used to regulate facial recognition. And at the end of the paper, Rui explores how to close that gap. Now, let me say from the beginning that I think that this is an incredibly important question. It's incredibly timely. And I admire how Rui tackles it in the paper. There are a few questions that came up as I read the paper. So, Rui, throughout the paper, you frame the main harm that facial recognition poses to people to be the potential corrosion or invasion of personal integrity. And it seems to me that the entire paper is sort of built around the challenges that facial recognition poses to personal integrity, which certainly I would agree with you that it does. But one of the questions that I had was your specific decision to focus on the value of personal integrity, which sort of echoes in dignity, which also echoes in sometimes I know that within the EU it is conceptualized the right of informational self-determination. And so one of the questions I had was whether your focus on personal integrity is intentional, right? So I wanted to know the sort of reasons why you focused on this value, because in a lot of the literature that's out there and in a lot of some of the other studies, facial recognition surveillance actually poses a number of different threats to several different kinds of values. And so facial recognition threatens discrimination based on things like affect recognition. It threatens due process rights. It has free expression implications. It enables harassment. There are concerns about equity with respect to vulnerable populations. There are societal interests in sort of moderate boundary pushing, being able to push the rules and break the law just a little, which facial recognition threatens a fair bit. And larger sort of the mutual faith necessary for society to work between people and public institutions that I think facial recognition technology starts to bring into question. And so one of my questions that I had, which I think it's completely fair to focus on personal integrity, but is whether you limited your inquiry into facial recognition of personal integrity because of the legal regimes that have been built around it that are available to regulate facial recognition technology? Or do you consider personal integrity to be a broad enough value to encompass all of these different harms? And so there's just a little bit of some explanation that I think you could probably build into the paper to make that a little clearer, because of course it's completely fair to say, I'm going to analyze the GDPR because the GDPR cares about data and facial recognition implicates data, while reserving some of these other also difficult questions for a different kind of analysis. And maybe it's a different paper, or maybe you actually do consider facial recognition and personal integrity to encompass all of these other different values. So that's one of the questions I had. Another question that sort of came up in your framing of the paper was that at several points in the paper, and at one point in specifically, you argue about how there are some exemptions provided within things like the GDPR, which actually comes down relatively robustly in terms of regulating facial recognition technology. And you say that there's a gap with respect to regulating facial recognition when you look at the GDPR and other regulatory regimes, because, for example, the consent model doesn't really work for facial recognition, but also it's not exactly clear what the other path to legitimizing facial recognition might be, given the sensitive nature and the category within which facial recognition surveillance falls into. And the way that it was framed in your paper, you identify it as a gap, right? It's sort of it's almost like a shortcoming of the GDPR. But one of the questions that I had that you might want to tackle a little is this the GDPR working exactly as it's intended? And could it be that one of the possible outcomes of this is simply that facial recognition in its current technological iteration is simply inconsistent with the GDPR, and then at that point, and maybe that is your ultimate conclusion. And if your point, and if your normative stance is, well, that's not good, what it then does is it falls upon you to then justify why you think that the GDPR and the values that the GDPR purports to serve, or other EU institutions, should be modified to then accommodate this new technology. In other words, what are some of the benefits that would require us to deviate the normal application of these regulatory frameworks in these instances? And so that was another thing that came up. And then finally, because this is a draft paper, and I know that you plan on additional work with this paper, and you plan to build out the backside a little more. There are parts of the paper that aren't built out as much. And so one of the things I just want to emphasize as you continue to build out the paper is that the quest to find what legitimate interests are with respect to processing this data, what legitimate uses are of facial recognition technology, strikes me as extremely important. And as someone who is across the pond from the EU, that spends a lot of time looking at some of the regulatory frameworks within the EU and thinking that the exemptions and the rules and the boundaries that are drawn are so broad you could drive a truck through them. I think it's important. I think this is a critical question, and giving out some of the very specific examples would be a really good way to build out what I think the ultimate quest of your paper is. And so it's just a plug, I guess, at the end to sort of hyper focus on some of the other provisions that purportedly would justify the use of facial recognition, because it seems to me that there's a lot of room for mischief in the vagueness of a lot of these standards. And so I saw you sort of approaching that area, and I would encourage you to build it out a little more. But otherwise, I thought this was a really interesting paper, and it's a really solid foundation to build out an entire research agenda, if you so wish. You could dedicate a whole career to biometric surveillance and data protection frameworks, I think. Next, Susie Dunn gives us a deep dive into the way that artificial intelligence now jeopardizes our identity in new ways, or maybe in worse ways than before. Susie's quest is to try to figure out what role the law is and should be playing in protecting people from the new AI-driven forms of identity manipulation, like deepfakes and artificial voices. Susie explores just why identity, particularly representation of people's image and voice, is more relevant than ever in our society. And Susie also covers why and how new technologies like deepfakes and voice manipulation threaten our identity in disturbing ways at scale, particularly given that these tools are now are quickly being democratized. So next in the paper, Susie explores the existing torts like appropriation of personality and publicity rights in the common law of Canada and the United States, and finds them lacking. She also focuses on the dignity and personality rights in the civil law systems of Germany and Quebec. Instead of sort of embracing these existing rules, Susie argues for legal solutions to identify violations of our identity that include more of a dignity-focused approach that takes a broad understanding of identity to protect people's identities from being harmed by misuses of new AI technologies. So Susie also, I loved this paper as someone whose own entry points into the law was through the common law of privacy, particularly the privacy torts. I love a good torts paper. I think that you did a really great job of bringing in multiple disciplines in the first part of the paper to and different perspectives to bear, bringing a lot of important insights. I mean, anytime you quote Goffman, I'm automatically in. And so in order to help the reader understand just how important identity plays out and how it's deployed here. And as I read, I just had a few thoughts that I thought you could incorporate as you continue to revise this paper. The first one is that I've done a little of my own research into deepfakes and written a little bit about it. And I spent a lot of time as I wrote this article thinking about how AI is truly different. And as I read your paper, I found myself wondering whether images and voices were truly distinct, or maybe just how distinct they were from other invocations of people's identities. Specifically, I'm thinking if you simply write about them, right? You invoke their name, or you invoke perhaps unique character traits. Now, I do think that the law is on your side here in terms of drawing a distinction. The law certainly tends to draw these sorts of distinctions between the regularly invoking someone's name. So, for example, I can say Susie Dunn without any perhaps dignitary harm to you, like I just did it, and I don't think I inflicted a dignitary harm to you. But if I invoke an image or your voice, then maybe that's something different. But I would love to see how. I would love to see that distinction fleshed out a little more, because you are placing so much weight on the actual difference between, specifically, I love that you actually specifically came out and said images and voices. I appreciate that the firm distinction is made, but I would love to see that sort of supported a little more, particularly with respect to the problems that we create. And a lot of it is, I think, probably intuitive. And so maybe you feel like you don't need to write it out. So, for example, if I do fan fiction, right? If someone writes fan fiction in a way that is very disturbing to someone's identity, maybe intuitively that doesn't sort of bear upon the same sort of harms or not. But one of the questions I had with this distinction is the reason you specifically focus on images and voices, is it purely because of the tools that are being created, which of course deepfakes implicate both images tools, both images and voices, or is it that there's something really unique about that? And if it is something unique, one of the questions that I had was, is it because of the power to deceive? So one of the reasons, and you get into this a little bit in the paper, one of the reasons that you get into this is because we could trick someone. Someone could. One of the real questions, of course, and you cite Danielle Citron and Bobby Chesney's work on deepfakes, one of the real problems is that we could convince people that it's real, right? So it would have me saying something like, I think the Boston Red Sox suck, and I don't think that, right? And or something like that, right? And something more dramatic than that. So that's the identity sort of the. And you think about this a little bit with your exploration of dignity, but is it deception, or is it that voices and images, unlike names, are more innately visceral? In other words, the evocative power itself, regardless of whether it's, I believe the deception or not, right, is enough to justify distinct legal treatment. Or maybe it's both, right? But if it is both because it deceives and because of its inherent evocative power, then it would be interesting to get your thoughts on whether those two things can be sussed out or not, because there are even additional legal remedies that apply for deception. And then you get into some really difficult line drawing problems when you talk about evocative power, right? And so I would just sort of recommend maybe at least potentially exploring that. There are some other, so in the paper you also raise some important distinctions that are, I think, really good to identify relevant factors that can make certain, for lack of a better word, identity interventions worse or maybe less harmful. And there are things like who is the identity, whose identity is actually being evoked? Like, is it a public figure or is it not a public figure? And you also ask, who is creating the replications? Is it a business entity, right? Or is it a hobbyist, right? An individual? And then the third question you ask is what is the drive behind the creation? Is it a social commentary? Is it for economic reasons, entertainment, experimentation, arts, intent to cause harm? These are incredibly important questions, and I'm glad that you brought them up. But it seems like a lot of weight hinges upon the determination of a lot of these factors with respect to your ultimate outcomes. And so because they are incredibly important. And if that's the case, I'd love to see you wrestle with them a little more. For some of them, of course, the law is clearly on your side and has long got frameworks that we more or less say work okay to make these distinctions. But for other ones, it's actually not entirely clear what's happening, and where to draw the line. And so given the law's struggle, even traditional struggle in making these distinctions, I'd love to see a little more discussion around that. And then finally, I had a similar question with your paper as I did with Rui, which is, does dignity, which you embrace as the sort of important value being served by identity, does dignity get you to all the way that where you need to be with respect to the use of these tools? Or is dignity the first step in unmooring the common law from harms and values that are more economic, like fiscal, or maybe more concrete in nature, right? So a lot of the problem, at least in the American system, I'm less familiar with Canada's system, which I actually really appreciate your paper for providing perspective on, from an outsider's perspective, is these torts fail so much because they do look for these sorts of concrete harms, or almost financially motivated harms, like some commercial misappropriation. And so is dignity a way to unmoor that, but you would want more? Or is dignity the whole bag, right? And it wasn't entirely clear from the paper whether it would be, but I'd love to see more of that. And Jennifer Rothman's book on the right of publicity, Privacy Reimagined for a Public World, may be a good place to draw some inspiration from that, because I think Jennifer tries to get at some of the related questions that you're asking. And then I also had some questions about when dignity is implicated in your ultimate prescription, which I love, by the way, in the sense that I love that you come out and give a legal prescription where you say, if we're going to have a test, a dignity-focused test, this is what it should look like. I think that a key important aspect of a lot of scholarship is just coming right out and proposing something. And maybe it's good, maybe it has some faults, but you do it, and then we can debate it. And I appreciate that your paper does that. And so in that spirit, I did have some questions about when dignity is actually implicated. Is it anytime my image is used? So your focus, of course, starts with consent, where you say, first, we should check to see if the person consented to the image. And even out of the gate, I had some concerns because I worry about modern consent extraction through mediated systems. So it's the whole GDPR, notice and choice in the US, I agree button consent problem. And I'd love to see you tackle a little bit of that as you build out the prescription, because if we're going to place weight on consent as a justification for what would otherwise be a dignitary harm, then I think you've got to tackle that consent problem. And then even beyond that, if there is no consent, then you go to a balancing proposal. And as a torts professor, you know, I love a good balancing proposal. It's like what we do in torts, right? But I didn't fully understand in your prescription whether you were arguing for a change in the default presumption about the invocation of people's identity, maybe specifically using image or voice. And so one of the things I want to know is what you're proposing a switch to where we have something like the GDPR, that the default presumption is that in fact you cannot process this image or voice, right? That only if it's legitimized can we do it, or would it still be by default I could use your name and image, I mean your voice and your image anytime I wanted, but if I hit a certain point, then I have triggered some sort of obligation or legal protection. Now this may seem like semantics, but in terms of actually how this would play out in practice, I think this making clear what sort of the default presumption would be is still going to be really important for the resolution that you prescribe. Okay, so those are my comments. I really appreciated both of these papers. Thank you so much for the opportunity to read them in the comment. And now I will turn it over. I guess we'll start with Rui first, because I gave Rui comments.
With regard to the first question, why I focus on personal integrity, it is because I found that there are many articles focus on privacy and not personal integrity, and I found that I can do such works on FRT on the risks that FRT poses to personal integrity. And I think that I can because I think FRT does pose a risk to personal integrity because personal integrity is in fact is interchangeably used with human dignity in the EU legal framework. It is protected under title of dignity in EU Charter, and because the Article 3 of EU Charter defines personal integrity, and personal integrity is consists of physical integrity and mental integrity. And I think that the collection of facial, because our faces constitutes the whole body of ourselves, and I think that it's because our face is an important part of our body, and so the wholeness and inviolability of our face is very important. And I think personal integrity is a basis of human autonomy, and it is a basis of other human rights. So I think this is the essence of the human human rights. It is a basis. So I intend to focus on personal integrity. And also because we are now in digital era, and our faces are stored in the form of data. So I think it's more, and personal integrity is more is a most suitable concept to FRT. So that's why I focus on personal integrity, not other human rights. And excuse me, can you hear me?
Yeah.
Yeah, because it's, and with regard to the second question, because could you sorry, excuse me, could you repeat?
Oh, sure. It was, well, first of all, I'll say, I think that's a great reason to focus on personal integrity. And as you revise the paper, I think it would be really great to draw some specific lines, and particularly as it relates to dignity. This is the relationship, I think, between your paper and Susie's paper, is thinking about, you talk a little bit about profiling in the risks. And I would encourage you to sort of build out the concept maybe of affect recognition as well. So whether you're happy or sad, for example, there are now lots of facial recognition tools. So I think that do that. And so draw a little bit more about the ways in which dignity is affected by facial recognition tools. The second question I had was, when you were identifying a gap in the regulatory frameworks for facial recognition, it seemed to presume that it seemed to me that you reached a conclusion that we can't use consent for a lot of these uses because of the way in which they're categorized, and it's not clear how otherwise we might accommodate the facial recognition tools. And so there's this sort of gap, this regulatory gap. At least that's the way I understood it. And if I understood it wrong, please let me know. But my question was, well, maybe is that the GDPR working exactly as it's supposed to? And is it possible that we've hit a point where the GDPR is one possible conclusion from your research, the fact that the GDPR is simply intolerant of facial surveillance?
You mean maybe facial recognition is not inconsistent with GDPR?
Oh, no. I mean, is it possible that facial recognition is entirely inconsistent with the GDPR? Like, is it
entirely inconsistent with GDPR? You mean maybe GDPR is sufficient for the FRT?
right? Yes, exactly. Like maybe it works great, and then we just don't get facial recognition technology because we can't think of a way to make it compliant with the GDPR as broadly interpreted. Which I read your arguments as being, well, that's actually a gap because then there's sort of no path through for facial recognition. And if that is your arguments, my potential question was, well, maybe is that the way that the GDPR is supposed to work?
Because first, I think that GDPR and LED is law enforcement directive. The two firms EU data protection framework, and I believe that GDPR and LED, I mean EU data protection legal framework can be applied to regulate FRT, because FRT generates facial recognition data, and facial recognition data is, of course, biometric data and personal data. So GDPR and LED can be applied to FRT. And you mean that GDPR is totally inconsistent with FRT? I think that because our facial recognition data can be used to easily review our identity. I mean, that's compared with personal data in general and compared with other biometric data. Personal data, facial recognition data should be maybe we can. There should be a high level protection to regulate FRT. I mean, because facial recognition data is so sensitive that we need to provide even more protection for facial recognition data. And as I mentioned in the paper, GDPR adopts the middle-out approach to personal data, and the traditional regulatory approach is the top-to-down. I mean, the traditional command control regulatory approaches. And since I argue that facial recognition should be more protection should be given to facial recognition data. So I think that there's what lies between the top-to-down approach and the middle approach is the is a better solution to facial recognition surveillance. And also, I can understand that why you think GDPR can be totally consistent with FRT, because there are also law enforcement directives that can be justification for law enforcement authority uses of facial recognition surveillance. And because but in addition to law enforcement authority, there are also a private sector that uses facial recognition for example, for sports shoplifter, and to perform regulatory purpose. So a lot of facial recognition data are collected and stored by public and private sectors, and because facial recognition facial recognition data usually collected without our awareness, and not even without our consent, and the GDPR, the traditional the EU data protection legal framework, is based on informed consent. That means our facial recognition data is collected without, but with the use of FRT surveillance, our facial recognition data is collected without our consent. So I think that the EU data protection legal framework, the informed consent model of EU data protection framework is not suitable for FRT surveillance context. So I think that the current EU data protection legal framework is not sufficient for FRT surveillance.
Right.
Yeah.
Thank you very much. I appreciate that. Susie, I think it's time for.
All right, we'll swap over.
Yeah.
Great. Yeah, no, I think a lot of the points you brought up were really relevant. I think the main reason I focused on image and voice, particularly for this paper, was mainly because I was submitting a paper to WeRobot that was looking for content on artificial intelligence and robotics. You know, and artificial intelligence and robotics, the content that's out there is it's robots, it's deep fakes, it's this fake voices, you know. So I was going with the technology for the purpose of the conference, but actually my research in this area originated from a gender-based violence perspective, and my interest in identity manipulation and misrepresentations actually comes from that area. And what we're seeing in the trends there is that people are using images, they're using written content. Some of it's true, some of it's false, and they're using this in ways to really harm people in intimate partner relationships. And this is where I really kind of started thinking, like, there's something about the space of how we exist on the internet that has a really unique value that's different. You know, and in the same way that, you know, a lot of our early privacy scholarship came out when cameras were invented. There was this new type of technology, there's a new permanence, you know, and now we have this new range of technology, whether it be, you know, our profiles on the internet, or, you know, virtual reality avatars that are created about us, or deep fakes. Technology's changing. And so I think we're at another moment in time where we're really having to revisit, what are the values of our identity? What are the values of our images? What are the values of our representations? You know, and I'm finding in the common law context, there's two things that we're a bit hunkered down on, I think. One is privacy. I think that we're really focusing mainly on privacy, and, you know, looking at the civil context, where rather than focusing almost primarily on privacy, they're really looking at these larger personality rights, which I think speaks more to that umbrella that you're talking about. Yeah. You know, it's the larger concept of, we have freedom of expression, we have dignity, we have our economic rights, and they're captured under this larger umbrella. And what I've been finding in at least in common law Canada, we've really, centered in on these 4 privacy torts that came out of the 1960s. And I think that we're not being innovative enough. I think that we're not being creative enough in our legal thinking, and we need to push beyond that, particularly as we're seeing these really interesting changes in technology. And I started moving more towards this dignity aspect because there was this fantastic case about 20 years ago in Canada, Aubrey, which was a case where a young woman was 17 years old and her picture was taken and published in a magazine without consent. And looking at the Quebec Civil Code and the Quebec Charter, which protects right to image and protects right to personality, they balanced the rights of this artist and journalist with this young woman, and found that she had those rights. And I was thinking, where is this in common law? Like we're not finding this in common law. And in Canada, we recently had a case where they applied the publication of private facts and false lights together and used both of these torts in a situation, because what we're seeing is that some of the information that's being published is true private information, and some of it is manipulated false information, and our laws don't have a way to capture that confusion that exists. So I think it's really important that we do that. And I think voices and images are particularly evocative. I think in the same, like in the work you've seen with, Danielle Citron, she talks a lot about how, there's something about video that's very convincing in a way that, written material isn't. So I do think that there is something interesting about images and voices and video that is particularly convincing that we need to look at. One of the other aspects that you brought up too was like, who's a public figure? And I think that's also very confusing, because when we look at our laws, historically, we were looking at newspapers, we were looking at public figures, and these lines were very definitive about what is a public space, what is a publication, and what is a public figure. Where now, we have, when does an influencer, an Instagram influencer, become a public figure? What is that line? Obviously, we have politicians, we have journalists, we have all those folks who are clear public figures. But in the modern era, everyone is kind of scooping up this desire to become somewhat of a public figure. So I think that the old ways that we looked at things, need to be reexamined and are being reexamined. I think that there have been some interesting legal cases that have examined that type of thing. But one of the things I found frustrating about the Canadian law and the American law, the appropriation of personality, was that it really wants us to value ourselves as corporate brands. And it's so easy. It's so easy for the law to say, this is what you're worth as a model. This is what you're worth as a corporate brand. That calculation is easy. And this is the problem with the law. And a lot of my research complains about this, where I'm saying we need to think about equality. We need to think about dignity. We need to think about inherent value, these things that aren't easily quantifiable. And the law doesn't want to go there because it's confusing, it's complex, and it's messy. And I think we have to. I think we have to commit to going there rather than only relying on what the economic value of who we are as humans are. And, and I think that's a lot of what this paper is getting at. And I think you're right. Maybe I can, flesh out a bit more than just dignity in that commentary. And I'm actually really glad the third point that you brought up, I'm actually really glad that you brought it up around, corporate influence in this. So often, because I mainly look at gender-based violence, tech-facilitated violence, I'm looking at individuals. I'm looking at families, I'm looking at partners, I'm looking at friends, I'm looking at coworkers, and we forget. And again, I think that there is a little bit of forgiveness in this corporate culture, but corporates are creating our profiles. They are defining who we are. They are manipulating our identities in complicated ways, and the way that we are reflected back to ourselves. And my supervisor, Jane Bailey, does really interesting work in this area. It becomes a part of how we understand others and how we understand ourselves. So I think thinking about how corporations are involved in our identity manipulation is really important, and how corporate consent and these places where, if we want to engage in digital spaces, which we have to, there's no getting around that. Often we click consent because there is no choice. And I think when it comes to models of consent in the corporate world and in our online interactions, like, we do need to think about that more. What is true consent? And if we are getting consent through those types of models, is it genuine, and should that be considered legitimate? Like if Facebook says, you know, and in the early days, Facebook did, I believe, do this, where, you know, when you posted their images, they got rights to it, you know, but no one read the paperwork, and all of a sudden your cute kid is on a diaper ad, you know, and you know, and you're wondering how that happened, you know. So I think it's really important that you bring up that corporate factor, because it is key, and honestly, right now, who is, you know, manipulating our identities are corporations more than individuals, you know, and this paper had a very individualist focus, mostly because of my interest in gender and personal interactions. But yeah, I really appreciate all those points. And on the final point on that balancing, you know, is it consent? Who's a public figure? Who's doing that? I think that's where I'm most interested in commentary from other people. Like, I want to hear what they think, because it's not a clear line. We live in a society where we love memes. I love sharing images. You know, I think that it's important that we get consent, but we are creating a new culture of when can we share information about people. And we don't want to create a law that's so limiting that, you know, if my, you know, aunt posted a Facebook picture of me up, that I can sue her. You know, like I think that, like, there might be some, you know, we don't want to see that, right? Like there might be some other exceptions, you know, but we don't want these laws so tight that we can't express ourselves or share information about other people. But that balancing factor for when we draw that line, I think, is the thing that I'm most interested in hearing from other people about, and so appreciate your commentary on it. So thank you so much.
Oh, sure. Absolutely. I mean, it occurred to me that as you were speaking, like, some of the things that you could do maybe in a different paper, or just sort of at the end, is think about what the spillover effects might be with respect to, if we were to adopt the tests that you prescribe, then is it possible that there would be incentives that would be changed, either for corporations or for people? So maybe in the deprioritization of the economic value of our identities, do we get some additional goods beyond just greater respect for dignity, for example, right? Might we see a decreased appetite for microfluencing the hell out of everything, right? Yep. For example, and maybe that's good too, right? So maybe there's a broader sort of appeal to the dignitary right that you could sort of flesh out. And so I think that's really good. And there's some really great scholars that I'm happy to offline. I'll send you some emails. Yeah. Jasmine McNeely is one who's done a lot of research into online communities, and particularly to the extent that they fit into some of these old tests that got created as to who's a public figure and why, and, you know, what's a real dispute in the modern age. And, you know, it helps avoid some of the, because it can be easy to get sort of nihilistic about some of this when you're like, well, everyone's famous for 5 minutes. Yeah. And there's no point in drawing any lines at all. But there are some scholars that I think are doing some interesting points there. So I don't give into that sort of nihilism. And just because I completely agree with you, just because a line is hard to draw doesn't mean we shouldn't try to draw it, or that we can't draw it. And even if there are exceptions that challenge the rule, that doesn't mean it's not bad.
No, and our lines are always moving. Like, this is the thing, as technology changes, as our values change as a society, like, even, you know, there's so many movements that are happening right now where all of our values are shifting, you know, and that's constant. And the law is always changing. Like, that's what's so interesting about the law, you know, is that, like, as society changes and as technologies change, the law changes with it, you know. And I think that, you know, we can explore, like, this is a line that we're drawing today, and maybe we'll revisit that line later, and we'll shift it, you know. But I do think that we can, you know, there's space to draw lines.
Well, that's a really good point. Unfortunately, I think we're running out of time, but that's a really good point to wrap up on, which is, as you two build out this paper, my sense for both of you is that you can draw these lines in the prescriptive sections even more firmly, and then, of course, justify why you've drawn them. But I think that you've got a great compass, you've got a great direction, and I would just encourage you to sort of keep going and to keep sort of drawing those lines, because I think you're both onto something really interesting. So unless there are any last words, I just want to thank you all for the opportunity and the We Robot Committee.
Yeah.
Yes, thank you for the three of you for that amazing conversation. So topical at a time where we're now living, like, online, on video, being recorded as of right now, but with, like, so many new questions and new issues. So thank you again for joining us today for this virtual session, and for everybody who has been watching online. And we look forward to welcoming you one day in Ottawa and next year for We Robot 2020. Thank you. Have a nice day.
Thank you.